So a bit about myself. My name is Brendan Barr. I'm an employment law advisor at LCF Law. I have over 25 years HR experience across a number of different sectors, including civil service, retail, manufacturing, education, NHS, logistics, and more recently, the care sector. I possess a wide range of experience dealing with a large employee relations caseload, including serious and complex allegations of sexual harassment. I now support LCF Works clients, advising them across the full remit of employment law and HR issues. LCF Works is the firm's retainer service, which we provide to employers who either may not have their own HR department or require specialist advice. I also assist individuals and other companies who may need support with specific issues. A new offer we have is that I'm able to act as in-house HR support for clients, for example, carrying out investigations and holding disciplinaries or other hearings. The following webinar is entitled Taking Reasonable Steps to Prevent Sexual Harassment. This webinar is about the new legal duty employers have to prevent sexual harassment. It will cover the reason for the webinar, what is sexual harassment, what does the law require and expect of employers, what can your organisation do to prevent sexual harassment, what does a sexual harassment policy need to cover, what are the possible sanctions for both employer and employee, and how your organisation should deal with any allegations. On the 26th of October 2024, as an amendment to the Equality Act 2010, the government implemented the Worker Protection Act 2023. This introduced a legal duty for employers to take reasonable steps to prevent the sexual harassment of their employees. As a result of the new requirements, employees now need to show they are taking positive action and not just dealing with the aftermath, but being proactive in dealing with sexual harassment. As part of the Employee Rights Bill, which was announced prior to this legislation, the government also announced a possible further amendment, which, if introduced, will mean employers will need to take all reasonable steps to prevent sexual harassment. Whilst it has not been defined what all reasonable steps looks like, it has been reported that some statutory legislation may be introduced. Following the publication of amendment paper at the beginning of March, another amendment that has been proposed is to increase the allowed time limit for bringing employment tribunal claims relating to sexual harassment from 3 months to 12 months. So this means that if employees do suffer from sexual harassment, they will have 12 months to bring their claim at an employment tribunal, rather than the 3 months it is now. Following several surveys, it was found that 3 in 5 women and 1 in 3 men have suffered from sexual harassment in the workplace. Alarmingly, of this number, 70% of the women and 80% of the men did not report the cases, with reasons for non-reporting ranging from not being taken seriously, negative impact on work relationships, and damaging career prospects. While these figures are worrying, there is a real impetus for change, as shown by the Me Too movement. There have also been a number of high-profile cases recently. As such, it's important that you have robust procedures in place to support individuals and deal with any allegations. What is sexual harassment, and what does the law require your organisation to do? Your organisation will probably already have policies that cover harassment, bullying, and victimisation. This session has been specifically created to cover sexual harassment in the workplace. The Equality Act defines sexual harassment as unwanted behaviour of a sexual nature, which has the purpose or effect of violating dignity, creating a hostile, degrading, offensive, or intimidating environment. The harassment does not have to be motivated by sexual interest, nor does it have to be specifically directed at anyone. Equally, it does not matter how the behaviour is intended, the effect may still constitute sexual harassment. Ultimately, it would be for a tribunal to determine if someone's behaviour was intended to have one of these effects. But it's important to note that when considering whether the conduct has the effect of violating dignity or creating one of the environments highlighted on this slide, the tribunal will take into account Section 26(4) of the Equality Act, which states that it also needs to consider the victim's perception, the other circumstances of the case, which can include the victim's past experience, and whether it is reasonable for the conduct to have that effect, i.e., objectively, would others have felt it was sexual harassment? This webinar and the draft sexual harassment policy we have produced are for those occurrences where the definitions of sexual harassment are met. Attendees will receive a draft sexual harassment policy, which will be sent out following the webinar. However, should you have any further questions, please feel free to contact us directly. We've covered the legal definition of sexual harassment, but what could it look like in the workplace? Some common examples are sexual advances, sexual jokes, gestures, comments, or personal questions, inappropriate touching and sexual assault, displaying of pornographic photos or drawings, spreading lies or rumors about a person's sex life, wolf whistling or catcalling, or outdated terms of endearment such as sweetheart, darling, babe, honey, etc. These are just some of the recent cases involving sexual harassment in the workplace. The female trainee project manager was awarded $360,000 at tribunal for the sexual harassment she suffered and numerous other issues. The male employee who was harassed by a female head teacher was awarded $9,000 at a remedy hearing. And the female designer harassed at a work Christmas party was awarded $19,000 at tribunal. As can be seen, there is no distinction with regards to gender, profession, or seniority for either the complainant or the perpetrator. So how is your company liable and what could the penalties be? Section 109 of the Equality Act states that employers are liable for discriminatory acts of employees during the course of their employment. In other words, this means that if an employee commits an act of discrimination, you as their employer are liable for any compensation awarded. You can, as a business, however, show that you took reasonable steps to prevent that act of discrimination taking place. Section 40A is a new provision which states that employers must take reasonable steps to prevent sexual harassment. And if they don't, they will not only be liable for their employees' actions as per Section 109, but that in line with another section, new Section 124A, that compensation can be increased by up to 25%. Any compensation awarded can include financial loss, if the employee was unable to work for a period of time, lost salary, or if they did not receive a pay rise bonus as a result of sexual harassment. This can also be adjusted to include future loss. Injury to feelings. Any compensation paid can also include an award for injury to feelings. Compensation payments related to injury to feelings are calculated under 3 bands. These are called the Vento bands. The lower band, which is for less serious cases where the act of discrimination may be an isolated or one-off occurrence, is $1,200 to $11,700. The middle band, which is for serious cases but which do not merit an award, in the highest band, $11,700 to $35,200. And the upper band, which is for the most serious cases, such as where there has been a lengthy campaign of discriminatory harassment, and this ranges from $35,200 to £58,700. It should be noted that in some exceptional cases, an award for injury to feelings may exceed the upper band. When calculating compensation, tribunals will focus on the effect the discriminatory act has had on the individual, taking into account a number of factors before deciding on an amount. These factors could include the vulnerability of the claimant, the degree of hurt, distress, or upset caused, and the position of the harasser, and the seriousness of the treatment. The Equality and Human Rights Commission has developed several pieces of guidance to support employers in taking reasonable steps to prevent the sexual harassment of their workers. As part of this, they have outlined 8 practical steps that employers can take to prevent and deal with sexual harassment in the workplace. Whilst this is not an exhaustive list, it's implementing these steps should help you take positive action to prevent and deal with sexual harassment at work. Step 1, developing an effective anti-harassment policy. Step 2, engaging with staff. Step 3, assessing and taking steps to reduce workplace risk. Step 4, reporting. Step 5, training. Step 6, handling harassment complaints. Step 7, dealing with third-party harassment. And step 8, monitoring and evaluating actions. We will look at the 8 steps in more detail and how you can utilize them to help you fulfill your legal duty to prevent sexual harassment in the next few slides. As I have mentioned previously, with the changes coming from the Employment Rights Bill, it could be that some of these steps become statutory legislation. The first step an employer can take is to have an effective anti-sexual harassment policy. The policy should include a number of relevant points. Confirm who the policy covers. State that sexual harassment is unlawful and will not be tolerated. Provide a definition of what sexual harassment is. State what the consequences are of being found guilty of sexual harassment. Set out a range of options for dealing with harassment. State what will be taken into account in deciding what action may be taken. And explain how employees can raise a complaint, although this should not be too restrictive and put employees off from reporting concerns and allegations. It should also explain what third-party harassment is, and it should provide details of any internal or external support. It may also be beneficial to consider whether there are any other policies that could be implemented alongside an anti-harassment policy, such as a relationships at work policy. Again, as an employer, you don't want to stop relationships from happening. However, a large number of allegations do come from the breakdown of a relationship. Following this webinar, you will have a draft policy to use. However, if you require further support with drafting any other policies, we can help with this, so please feel free to get in touch. Step 2, there is no point in having a policy if staff are not aware of it. As such, engaging with staff is a vital step in taking positive action. Ensure staff know you have a specific policy, where it can be found. Put up posters in staff communal areas to make people aware. Discuss the policy and any issues in team meetings and briefings. Ensure staff know who, how and where they can report issues to. Discuss in one-to-ones and run staff surveys and have specific questions on sexual harassment in the workplace. And finally, hold exit interviews. Some staff may be more willing and less reluctant to discuss issues if they are leaving. Step 3, undertaking risk assessments and reducing risk. These can help you comply with the preventative duty. Consider the factors that might increase the opportunity for sexual harassment and the steps you can take to minimize them. So where are the power imbalances? Which staff have responsibility for rotas or staff incentives? Do teams lack diversity? Do they consist of more of one group than another? Are there any specific roles with less job security? Lower paid roles may be more susceptible to abuses of power. Do staff often work alone or during the night? There may be less management oversight or support available. Are staff customer facing? Is there an increased risk for third-party harassment? Is there alcohol on site? Alcohol lowers inhibitions and may make people more likely to act inappropriately. Are staff required to attend external events? Are there risks that are outside of your control? Do staff socialise outside of work? Whilst you don't want to stop staff from socialising, they need to be aware that dependent on circumstances, this could still be included in the definition of workplace. And finally, what is your work culture? Are banter and crude comments the norm? Equally, there may also be certain times of the year or even week when instances of sexual harassment may be more likely to occur. As we know, staff parties or some attendees can at times get out of hand, and it's often a nervous time for managers and HR departments. This could also be the case with large-scale sporting or music events where people may be more likely to act differently than they would normally. This is equally relevant to staff and third parties. It may be worth reminding staff of the policy and their personal obligations before such events. Step 4, reporting. Businesses should keep a centralised, confidential record of all concerns raised either formally or informally. This will support managers in recognizing recurring issues or trends, enable things to be put in place to prevent them in the future. You could consider using an independent reporting system, such as an online or telephone system. However, and staff may feel more comfortable raising issues anonymously. Although it should be noted that there are some downsides to anonymous reporting systems, in that it can often be more difficult to investigate allegations if you are unable to talk directly to the affected individual. Step 5, training. All employees, including managers and senior staff, should undertake regular training, which should cover what constitutes sexual harassment in the workplace, how to recognize unacceptable behavior, what to do if you experience or witness sexual harassment, and the company and personal obligations. In industries where third-party harassment is more likely, such as hospitality, staff should also be trained on how to recognize and address these issues. Handling complaints. Staff responsible for dealing with allegations should also undertake training to cover how to handle complaints of harassment. Training should be reviewed to ensure its effectiveness, and refresher sessions should be held on a regular basis. Recent case law suggests that any training provided must be kept up to date. In one case, an employer was unable to rely on the defence of taking all reasonable steps to prevent discrimination when the training it had provided had taken place 2 years before the acts complained of. Step 6. Handling complaints. How you deal with a complaint or allegation is also important. As such, it is vital that when an allegation or complaint it is dealt with immediately, act quickly to deal with the complaint, taking into account how the individual wants it to be resolved. Respect the confidentiality of all parties. This includes the complainant, any witnesses, and the alleged perpetrator. Protect the complainant and any witnesses from any ongoing harassment or retaliation for raising a complaint. Remember, 37% of people said the reason they didn't report an issue was due to it negatively impacting workplace relationships. Harassment can be classed as a criminal offence, so speak to the individual about whether they want to raise the issue with the police or other external organisation. Confidentiality agreements or NDAs should only be used where it is lawful, necessary and appropriate to do so. The Employment Rights Bill currently going through Parliament contains a clause banning the use of NDAs for sexual harassment disclosures. Always communicate the outcome of any investigation to the complainant and outline any appeals process, remembering to maintain confidentiality. Step 7, third-party harassment. Harassment by third parties such as customers, patients, clients or suppliers should be treated just as seriously as that by colleagues. Steps should be taken to prevent this type of harassment, including policies, reporting mechanisms, and/or assessing areas where staff may interact with third parties. How you handle complaints and allegations is important for all concerned parties. As such, we will go into more detail around how you should deal with the complaints later in the presentation. Step 8, monitoring and evaluation. As with training, it's important to regularly evaluate the effectiveness of the steps you put in place and implement any changes needed. This will help underpin your ongoing duty to take reasonable steps to prevent the sexual harassment of your employees. Ways in which you can evaluate the effectiveness of the steps you've taken are: review informal and formal complaints data to identify any patterns, trends, or particular issues and what actions were taken. Survey staff anonymously on their experiences of sexual harassment, including whether they have witnessed or been subject to harassment, whether it was reported, and if not, why not, and what further steps they think you could take. Compare reported complaints against survey feedback to ensure you have an accurate reflection of the level of harassment and take appropriate actions. Hold lessons learned sessions for key staff after any complaints of sexual harassment are resolved. Policies, procedures, and as previously mentioned, training should all be reviewed regularly, especially if you are still receiving complaints. It is also beneficial to seek input from staff or their representatives to consider if any further changes are needed, and these should be implemented where appropriate. Consider whether there have been any changes to the workforce or workplace that could mean there are further steps it might be reasonable to take. Employee sanctions. As well as facing disciplinary action, employees may face other sanctions. They could lose their job, they might be banned from working in their chosen profession, they may also be personally sued, and they could be found personally liable for any compensation awarded at a tribunal. Often, when individuals bring claims of harassment and/or discrimination, they will bring those claims against both the employer and the alleged perpetrator. And if both are found culpable, then both can be responsible for any compensation awarded. This is called several liability. Where liability is several, it is possible to proceed against each entity individually and recover from each entity individually. However, if an employer can show it took reasonable steps to prevent harassment taking place, such as implementing the 8 steps in the previous slides, then it may be the perpetrator who alone is found culpable for any compensation. Equally, if the allegations are serious enough, they could receive a prison sentence. This can often be one of the most powerful messages to get across to employees, as once they understand they may be personally liable, they may be less likely to harass people. So, in summary, sexual harassment is defined as unwanted behavior of a sexual nature which violates your dignity and makes you feel intimidated, degraded, or humiliated, or which creates a hostile or offensive environment. Anyone, regardless of gender, age, role, or profession, can be a victim or perpetrator. Employers and employees can be held liable for complaints of harassment. Implementing the 8 steps provided by the EHRC can support employers to comply with their positive legal duty to take reasonable steps to prevent sexual harassment. It's important to remember that just having a policy is not enough for an employer to rely on the statutory defence. Employees must be made aware of the policy and should be provided with training explaining what harassment is and what they shouldn't do. Both employer and employees can face sanctions if an employee is found guilty of sexual harassment. However, an employer can show that they took reasonable steps to prevent this. Employees can lose their job, be personally sued, and receive a prison sentence. We can support with any training that you may need for your staff. Please contact me directly if this is something you would be interested in. We touched earlier in the presentation on how you should handle complaints and how important this is. As such, we will go into more detail about this over the next few slides. Your organisation has a duty of care to protect its employees. It can be held vicariously liable for the actions of its employees. It should investigate all allegations of harassment. It should review current policies and procedures and adopt measures to prevent it from happening. Depending on the industry you are in, it may be necessary to report behaviour to a regulatory body or other external organisation such as DBS, the local authority, the GMC, or the SRA. Handling sexual harassment. Step 1, seriousness. All complaints should be taken seriously. We have previously mentioned that between 70 and 80% of those who have been harassed did not report the incident, with the main reason being that they wouldn't be taken seriously. If you do not show that this is a serious matter, it will send a negative message to staff. It may stop other people from reporting issues, and it may also make other people think they can get away with it. The longer it takes to respond and react to a complaint, the less impact it will have. Discuss with the complainant how the allegation will be dealt with and by who. You should also discuss with the complainant how they would like the issue to be dealt with, either informally or formally. Although this is somewhat dependent on the complainant, you should also consider the seriousness of any allegation. Step 2, support. Raising allegations can be very distressing for all parties concerned. Confidentiality should be maintained at all stages of the process. You should support the complainant and any possible witnesses. You may have your own employee assistance program. Equally, there are a number of external providers that can provide support to affected individuals. You may also consider keeping the parties apart while any investigation is ongoing. You could, depending on the seriousness of the allegations, choose to suspend the alleged perpetrator. Step 3, investigation. Investigations should be conducted fairly, sensitively, and confidentially. Investigations are purely fact-finding exercises. They are not there to apportion blame or guilt. They should focus purely on the allegations and what happened from all parties' sides. So plan your investigation. Think of questions you could ask beforehand. What information are you trying to gather? Use open questions. Use 5 W's. Who, what, where, when, and witnesses. Don't put words in people's mouths. Give people the opportunity to speak. Ask questions such as, can you explain what happened? Can you explain what you saw? What is your recollection of the events? Did anyone else witness the incident? Similar questions can be amended depending on who you were talking to, either the complainant, witnesses, or the perpetrator. Investigation should be unbiased. We would advise having someone there to take notes of any meetings, maintaining confidentiality. This will ensure that there is no disagreement between what has been said. Depending on the seriousness of the allegations, you may let the complainant or other witnesses or the perpetrator be supported during the investigation process, although this is not a legal requirement. Accurate records of any statements or interviews should be taken and kept. These will need to be provided should the matter be progressed further. Managers should consider if any other relevant parties need to be notified. Do the complainant's manager or colleagues need to be made aware? How can this be done sensitively, keeping confidentiality in check? Discuss with the complainant about making other people aware who may need to know and why for support, etc. What you are trying to do as an investigator is to be able to make a decision, given the evidence and statements, as to whether you believe there is a case to answer and should the issue be forwarded to disciplinary. It is not the investigator's remit to say whether the perpetrator is guilty of the allegations or what any possible outcome should be, other than if there is a case to answer. We can provide support and guidance around any investigation and disciplinary processes. Equally, as previously mentioned, we are able to come into your business and run any investigations and/or hearings for you. Step 4, outcome. How you deliver the outcome is just as important as how you deal with the rest of the process. Maintain confidentiality for all parties, remembering that the perpetrator has the same rights to confidentiality as the complainant and any witnesses. Outline any appeals process. Continue to support any individuals involved. They could be impacted physically, mentally, and emotionally for a long period of time. Advise the complainant if you pass the information to any other parties, again, maintaining confidentiality. If the perpetrator has committed a criminal offence, then you should notify the relevant authorities. Do not use NDAs to stop people from discussing complaints. The Employment Rights Bill includes a specific clause which would make the use of NDAs for raising harassment allegations, including those for sexual harassment, illegal. Following any allegations, review current processes and procedures, taking into account the specifics of the case. This can include policies and procedures. Are they fit for purpose? Training. Is this up to date? Have all employees completed it? And the work environment. Has anything changed, such as workplace or staffing? So in summary, you have a legal duty to protect your employees from sexual harassment. This includes putting steps in place before any issues are raised, not just dealing with complaints after they have happened. All allegations of sexual harassment should be taken seriously. You should support the complainant and any witnesses both during any process and after. Allegations should be investigated fairly, sensitively, and confidentially. Accurate records and notes should be taken and kept. Deliver the outcome to all relevant parties as soon as is reasonably practical, remembering the confidentiality of all parties. Remember, employees should be made aware that they can also be held responsible for allegations of sexual harassment. This means they could be sued, held liable for any compensation, or even sent to prison. We have received some questions in the Q&A text, so we will look at those now. So the first question is complimenting someone on their appearance classed as sexual harassment, such as that dress looks nice? No, that wouldn't be classed as sexual harassment. As long as it's not of a sexual nature, saying something like that dress looks nice is fine. However, saying something like that dress makes your bum look nice would be classed as sexual harassment. Second question, a colleague said they overheard someone say something inappropriate. What can I do? I would say what you need to do is raise it with the relevant people initially, such as HR. You could speak to the individual direct. However, I would raise it with HR initially and make sure that people are aware of it. The conversations and the comments don't need to be aimed at any individuals to be classed as sexual harassment. Next question is, a lot of our staff socialise after work. Could this still be classed as sexual harassment in the workplace? Yes, it can. Just because something has happened outside of the actual workplace, it could still be classed as happening at work. As such, you have a legal duty to take positive action and action against that. Could anyone be the perpetrator? Absolutely. Anyone of any age, any gender, any seniority, anyone can be the gender. As shown in the previous slides with the 3 complaints, it ranged from everybody within an employee, within an employer and an organization. Next question, somebody was made aware of an incident from 3 months ago. Can you still do something? Yes, you can still record and report the allegations. It may be more difficult to investigate and do something about it, given the timescales, as people will often forget what happened and not be willing to talk because it happened so long ago. But you still have a legal duty of care to look into those allegations, yes. And how much can someone be awarded for a sexual harassment claim? To be honest, a sexual harassment claim, it's the actual award is unlimited. As we've said previously, it can be looked at for future loss as well and adjusted for future loss. And also the injury to feelings awards can go up very high. One of the incidents we've had, somebody was awarded £360,000 at tribunal for numerous allegations and numerous instances of harassment that she'd suffered. Oh, we have another question. A senior manager who hugs people. He has done this for years. And nobody has ever complained. Should we tackle the issue before anyone complains? Absolutely, you should tackle the issue. As I've said, the new duty is a positive legal duty. So you have to take positive action, which means tackling sexual harassment before it happens. So if you know something like this is already happening and it could lead to a claim for sexual harassment, then yes, you should deal with it immediately and as quickly as possible. Obviously, you keeping sensitive and confidentiality as well. Are there resources available to help victims of sexual harassment? There are a number of resources, both nationally and locally. You may have your own employee assistance program, which can help. Equally, a number of external bodies, the Equality Advisory and Support Service can help. There's a support service called Protect, Victim Support, and Rape Crisis. These are all national support organisations, so there may be local ones in your area that may be more useful for you. We have a supplier, client, customer who is very flirty with all the female staff. Nothing has ever happened as far as we know. Should we raise this with them? Yes, this would be classed under third-party harassment. It should be raised with somebody, whether this is with them directly or their employer. Just because nothing has happened doesn't mean it isn't an issue. It comes down to how people feel about this. Remember, between 70 and 80% of people don't officially report issues. So another question, would there be a difference in sanctions issued if the issue occurred at an after work event compared to during work event? No, it depends. If it's a work event, although it's outside of work times, it would still be classed as workplace sexual harassment. As such, there would be no difference in the sanctions. As I stated previously, work events can and should be classed as workplace, especially if it is a work event. So no, there shouldn't be any shouldn't be any difference in sanctioned issued outside of work. The perpetrator may want to argue that it wasn't a work event, but I think if you've done your full investigation, then you can show that it was still classed as a work event if work people were there. Are there going to be any further changes when the Employment Rights Bill comes into force? Yes. Yeah, we already know that they're increasing the time frame for being able to put in claims from 3 months to 12 months. We are of the understanding that one of the changes to change from taking reasonable steps to all reasonable steps. And this is, we think, likely going to include some legislation that is statutory, such as maybe a policy and procedures, and following the Employee Human Rights Convention 8 steps. We will issue the draft policy to attendees shortly. If you have any questions on this topic, or if you are interested in our LCF Works package, or how LCF Law can support your business, please contact either myself or James Austin. As previously mentioned, the Employment Rights Bill is currently making its way through Parliament, so we are anticipating a large number of legislative changes going forward. We will hopefully be running more webinars and events, as well as publishing articles and blogs as new legislation is implemented, so keep an eye out for what's coming up. Equally, if there's anything you would be interested in seeing or hearing about, please feel free to contact us direct.